Good morning, everyone. Thank you for joining us for the Guardianships, Rights, Remedies, and Responsibilities webinar. I'm going to give it about 1 minute or so just to let all the attendees get in the room. We'll get started in just a moment. Good morning. Thanks for joining us. We've got people coming in rather quickly, but we've got a lot of material, so we're going to go ahead and get started. It looks like we've got a lot of our attendees on here already. So my name is Lainey Jennings Hall. I am the Marketing and Communications Manager at Disability Rights Arkansas. I will be your host and moderator today, and thank you for joining us. We'll be talking about guardianships, rights, remedies, and responsibilities with Thomas Nichols. Thomas joined DRA in September of 2015. He received both undergraduate and graduate degrees from Henderson State University before earning a Juris Doctorate from the Bowen School of Law. A practicing attorney for 10 years, Thomas worked in private practice before joining DRA, litigating medical malpractice and catastrophic injuries. He is licensed in the state of Arkansas, United States District Court for the Eastern and Western Districts of Arkansas, as well as the 8th Circuit Court of Appeals. Excuse me. In addition to supervising the program staff who supply advocacy and legal representation to individuals with disabilities, he has represented individuals who are subject to guardianships, assisting them with reporting abuse or neglect, seeking independence, and asserting their rights. So as you've probably noticed, this is a webinar and your video and audio are automatically turned off for the duration of this webinar. If you have questions, make sure you drop them in the Q&A section. We also ask that you help us to keep this session as accessible as possible by limiting chat posts. So please use the private message feature to say hello to friends and any side conversations. This will ensure that our attendees using screen readers will be able to hear the speakers as everything posted in the chat pane is read aloud by the screen reader. If you have any event-related issues or sound or anything like that that I may be able to help with, you can direct message me. My name on here is Lainey, DRA moderator. So feel free to direct message me if you have questions. This session is recorded and will be available as long as some great resources that will pass along to you shortly after. A reminder, if you do need closed captioning, there is a CC option at the bottom of the screen. And then our transcriber will also drop a link in the chat. All right, I'm going to turn it over to our speaker, Thomas. Maybe, there we go. All right, Thomas, there you go. Thanks for joining us.
Appreciate it. I'm not used to being on mute for very long. Thanks everybody for joining us. Like Lainey said, my name is Thomas Nichols. I am the Director of Advocacy and Legal Services here. By virtue of that, I supervise what we call the program work of our organization, all of the legal representation and advocacy and investigations that our organization undertakes. We are the protection and advocacy system for the state of Arkansas. Every state and territory has an organization like ours. So there are 57 of them. And each one of us is tasked with investigating allegations of abuse, neglect, and exploitation when it regards people with disabilities of any type. We handle some limited special education work. We handle Medicaid cases. We have a specific grant that's for auditing representative payees. We assist with vocational rehabilitation and efforts to secure any goods or services that are necessary for vocational rehabilitation, and we assist people with removing barriers to employment. I'm sure I'm forgetting something that we do, but nevertheless, please visit our website if any of that is necessary to be reported, or if somebody needs legal representation or advocacy. If we can't assist you, we will try to find somebody who can. But today, we are going to be talking about guardianship. And I've got a lot of material to go through. I'm going to try to leave some time at the end for questions. I do want those of you who have questions throughout to put them in the Q&A. I will try to address them as we go along, but I do want to reserve some time at the end in case anybody has any questions. And because of that, we might not get through the entirety of the presentation, but we will make it available afterwards for those who want to learn more. So we're going to be referring back to this first slide fairly often. It's going to pop up throughout the presentation because guardianship really has to be considered as part of a spectrum of what decision-making supports there are. Guardianship is all about decision-making. It's all about who is able to make decisions and also who is not able to make decisions. And we're going to go through each one of these parts of the continuum of decision-making supports throughout the presentation. But as you can see, we have put it into a list that kind of works like a chart that starts with the least support to make decisions to the most support to make decisions. And thinking of it more in terms of not just who can make decisions, but who cannot make decisions. So if you start at the least restrictive form of decision-making support, obviously that is the person making decisions. Nobody is making decisions on their behalf. They're unsupported in making those decisions, and they are just making decisions on their own. There's no help from anybody. The next step below that would be supported decision-making. Again, we're going to get into later on what that is as a less restrictive alternative to guardianship. But supported decision-making, the person is still making their decision, but they're making it with the input and the support of another person to help them make decisions on their own. Nobody is making decisions on their behalf. However, somebody is there in order to supply them with information, with advice, and to perhaps help with what communication barriers there might be or understanding barriers there might be. But in the end, it is an individual who is making their own decisions. The next step is an advance directive or a power of attorney. Now, in that part of the spectrum, we have an individual who is authorized by the person to make decisions on their behalf. However, the person, the individual, they are still retaining all authority to make their own decisions. If you supply somebody with a power of attorney to execute a contract or to deposit funds into an account or to access medical information, you still, as the individual, retain the right to do that on your own. And furthermore, you have the right to revoke that power of attorney at any point. So in essence, it is still the individual who is making the decision. They're just also giving that authority to another person. And while that might not always be able to be undone, the decision that that power of attorney might make, it is still giving the individual the authority to make their own decisions that are counter to what that power of attorney does. And similarly so, an advance directive is you, the individual, making a decision, putting it on paper, maybe authorizing somebody else to make decisions on your behalf, but it is a list of your directions. It is a list of your decisions that are then to be honored in whatever way the advance directive directs. And we'll talk a little bit about what's called a psychiatric advance directive, which is something that our state permits and is gaining a lot of traction across the nation as a way for individuals to outline exactly what type of psychiatric services they should receive in the case that they are later made incapacitated by a by a mental illness. There is a question in the chat about what about court-appointed powers of attorney? Can the person revoke a court-appointed power of attorney? Well, if a court is appointing a power of attorney and it's already gone through that process, it's not the type of power of attorney that we're talking about. Under circumstances in which a court is choosing a power of attorney, I don't know that there would be the authority to revoke it without being able to show the court that the power of attorney is no longer necessary. What this might be is when you're talking about somebody who is found to be incapacitated, a court-appointed power of attorney in a lot of circumstances will then act as a limited or a temporary guardian for limited time or limited scope. So we'll talk a little bit about that later. The next question, is it not true that a person choosing to elect a power of attorney must be cognitively able to revoke this decision? Now, that's a very good question. Arkansas law is not really well developed when it comes to what is the capacity, what is the evaluation that we have to undertake in order to either execute or revoke a power of attorney. We have researched the issue at great length, and we don't come up with a very good answer. The best guess would be is that they have to have what's called testamentary capacity, but that's only because there's no other good standard. Generally speaking, will the individual who executes or in turn revokes the power of attorney, do they have to have the ability to appreciate what it is that they're doing? Do they have to understand what they're asking the power of attorney to do? And the answer would be yes. It is a form of, I hate to call it a contract, but it really is. It is an agreement that authorizes another individual to act on their behalf. So they have to be able to understand what it is they are giving that power of attorney to do. I understand that I need this action undertaken on my behalf, maybe not in those words, but I want them to do this thing because I don't want to have to do that. It might be so simple as understanding that. And the same goes for revoking it. I don't want them to make decisions for me on this thing anymore. So I want to continue making my own decisions. So if they understand that that's what they want to do, arguably they would be able to revoke it at that point. Making our way down the continuum of decision-making supports, the next step in the process is a representative payee. Now, I highlight that as one of the parts of the continuum of decision-making supports is because representative payees are not nominated by a court. They're not overseen by a court. But they do maintain control of, in the case of the representative payee that I'm talking about, all of an individual's Social Security funds, whether they're getting supplemental security income or Social Security disability. Social Security has a program in which they can place a representative payee. It doesn't require a guardianship to be in place. Anybody who has a need for a representative payee to handle their finances can do that through the Social Security process where there is a need for one. You will have to supply information representing that there is a need for it, but in the end, it is a person who is charged with the obligation and responsibility to make sure that that person's money is managed in a way that supplies them with the food, the shelter, the medical care and services that they need in order to live. They are monitored, audited, whatever you want to call it, by Social Security, sometimes more frequently than the courts would require monitoring or accountability. They have to file accountings on a yearly basis, just like they might have to do if ordered by a court in a guardianship. So Social Security is continuously getting reports of how that money is spent. And if they're not producing it or they're not using it in a way that is beneficial to the individual, then they can revoke that status as a representative payee. And in some cases can even seek criminal penalties or reimbursement. A question from the chat: the rep payee cannot misuse any funds due to overspending the budget. Well, that's an interesting question. Yes, they cannot misuse funds if they are overspending their budget. I don't know that there exists any obligation on them to go out of pocket at that point. They can't get any more money from Social Security, but yes, they are required to use funds in a way that follows Social Security's requirements. The next step on the continuum of decision-making support is substitute or surrogate healthcare decision maker. So that is somebody that is appointed after an individual has already become incapacitated. They have substituted decision-making authority for an individual who doesn't have capacity to make decisions for themselves at that point. You can identify an individual, and that works kind of like an advance directive, or that individual can be appointed by a court on a temporary or a more permanent basis. A question in the chat about recommending to file guardianship or power of attorney prior to age 18. We'll get to that later. The next step is a court-appointed guardian or conservator, and that's really what the majority of our session today is going to be about. So guardianships in general, they have to go through a court process. There's no such thing really as a informal guardianship that has any authority over an individual, or at least none that would remove that individual's decision-making from them. You have different levels of guardianship, different durations of guardianship. It can go from temporary for a limited basis to a more permanent basis where you can no longer terminate that guardianship unless a court has determined that it's no longer necessary. You could also have limited guardianships only of one area of an individual's life, or only with respect to certain matters. Or you can have what's called general or plenary guardianships, which is every aspect of that individual's life is now subject to somebody else making decisions on their behalf. So guardianship, the original intent of guardianship, of course, it derives from, Roman and the combination of English and American law. It's part of the government's authority to exercise parental rights over individuals who require it. And originally, it was intended to prevent the public burden of caring for individuals, or to find individuals to make decisions on behalf of individuals who can't make those decisions. But it was also designed to ensure the protection of inheritance, to make sure that a person's wealth was not spent by somebody who could not make decisions on their own under the perception of a court or the government, and that any part of an individual's inheritance wasn't spent unwisely. Guardianship I don't want to give the impression that there is no such thing as a necessary guardianship. There are good aspects to guardianship. It offers some protections against abuse. It provides predictability for who is going to make decisions on behalf of an individual, and predictability about who can't make decisions. And it does provide standards for how those decisions ought to be made. There is what's called a fiduciary responsibility for an individual who exercises guardianship over somebody's estate. So they can't unwisely spend somebody's money, or they can't waste somebody's money if they're acting as the guardian of their estate. There are bad things about guardianship. It is the loss of legal personhood. One of the primary aspects of personhood is the ability to make decisions, and guardianship is sometimes colloquially referred to as a civil death because it is essentially a death of the civil person. It is a death of some of the civil rights that an individual enjoys. They lose their right to make decisions about every aspect of their life, how their health decisions are going to be made, who they're going to associate with, what they can purchase on their own behalf. And it denies individuals what's called the dignity of risk. We all make good decisions and bad decisions. Some of us make more bad decisions than others, but the dignity of risk is being able to make those bad decisions if it's safe, in order to determine what should we have done differently. It's an opportunity to learn. It's an opportunity to change your behavior if necessary. We learn through being able to appreciate risk. We learn not to touch a hot stove by having touched it. Now, granted, there is a reason to insist that people can do so safely and responsibly, and that is certainly appreciated. But when you remove everybody's decision-making authority, it removes the opportunity in some cases for them to be able to form their own reasoning skills and be able to modify their own behavior in the future. So where do we get our basis for guardianship in Arkansas law? Well, we have to determine what is an individual who is incapacitated, because that really is the standard for who is eligible for a guardianship. So an incapacitated person, we don't use the word incompetent anymore to describe an individual who requires a guardianship. And part of that is because it is a demeaning term, incompetency, but incapacitated really is a better word to use because it's more accurate to say that guardianships do not have to be viewed as all or nothing, forever or for no time. So incapacitated can mean that an individual's impairment might be transient. It might go away. They might only have a need for a limited time, but also they might be incapacitated with one area of their life and be perfectly able to make decisions regarding every other aspect of their life. So the standard is often overlooked when individuals are considering whether a person needs a guardianship, but they have to lack a sufficient understanding to make or communicate decisions to meet essential requirements for health, for safety, or their estate, which is just a fancy word for managing their finances. So if an individual is able to make those decisions to meet the essential requirements. Why are we saying essential? Because people make bad decisions all the time. You know, we don't always need to put what our perception of a bad decision is on an individual when they have done so safely and might have made a bad decision responsibly. I have made bad decisions. I've made bad purchases, but there is a reason why we say they have to meet essential requirements for health and safety, because while I have made bad decisions, and I'm sure we all have, I can still meet the essential requirements for my health, my safety, and to manage my own finances. The different types of guardianships, like I said, they could be limited in duration, they could be limited in scope. So the two different types of guardianships that we see very often are guardian of the person and guardian of the estate. And where these differ, the best way to think about it is guardian of the estate first. It is guardian over all finances, everything, all of the property, all of the stuff, all of the money that an individual has. That could be money that they earn from working, that could be money that they have in retirement for individuals who might have that. It could be money that they get from Social Security. That is the estate. And you can just be a guardian over somebody's finances. And why I say to think of that first, the estate first, is because guardian of the person is really everything else about an individual's life. It is health decisions. It is where they live. It is who they can associate with. It's all aspects that are not how an individual spends their money and on what. Now, sometimes these can cross over, which is particularly interesting to see if an individual is a guardian of the estate, but not guardian of the person, because essentially that might mean that the individual who is under that guardianship might be able to decide where they live, but then depend on the guardian of the estate to make decisions about whether that's going to be paid for, since they're required to do so in a way that benefits the person under guardianship. They would have to do that, but that's where those two decision-making authorities can collide. And I have seen the issue come up with a guardian's ability to, or a ward's ability to go out and purchase a cell phone. If they're the guardian of their own estate, they have control over their finances. They could essentially go out and purchase a cell phone. Well, how does that collide with the guardian's decision on who they can communicate with, which is something that we will be talking about in a little bit. So those two can collide, and we don't always know the answer, which is why we have a decision maker in the court system. If you're a guardian of the person and the estate, we call that a plenary guardianship or a total guardianship. And you can also have limited guardianships, and that might be, again, for something less than the individual's entire estate. Perhaps you want to only manage their Social Security funds, but they also have a job. And so you're going to let them manage their income from their job, but not their Social Security funds. There's lots of ways it can be limited, not just in time, but also in scope. Lots of rights are impacted by guardianship. Marriage and reproductive rights, where you travel, where you live, how you access your own finances, decisions about health care, your right to contract for things like cell phone plans and cars. Your ability to do that is impaired if you are under a guardianship with a finding of incapacity. But one of the things I want to touch on briefly but highlight is your right to vote. It might not be common knowledge to everybody that when an individual is appointed a guardian, they automatically no longer have the right to vote unless the court that has granted the guardianship has given that right back to the guardian to authorize the person under guardianship to vote. It used to be prior to 2001 that a guardian would have to go to court in order to prohibit an individual under guardianship from voting. But in 2001, they changed it, and the opposite is now true. You have to go get a court order in order to authorize a person under guardianship to vote. Now, this creates some issues, understandably. There isn't really a standard for a court to make a decision about whether an individual should be authorized to vote. I would say if a guardian and a person under guardianship both want that individual to vote, it should not require anything other than a motion and an order. It doesn't need inquiry. It doesn't need review. And in fact, when we have had an individual and their guardian agree, we have not yet seen an instance where a court has reviewed that case or had even an inquiry into whether that individual ought to be authorized to vote. So we would take the position that any inquiry might be inappropriate, because if I am going to make the decision to vote, I don't have to prove that I read the news. I don't have to prove that I know who I'm going to vote for before I walk in that booth. I don't have to tell anybody who I'm going to vote for before, during, or after I am voting, other than casting my ballot. So why then should we put that onus on an individual under guardianship to show that they somehow qualify for the right to vote when we don't do that for the general population at large? So moving on from that, we'll talk about temporary guardianships. Of course, a lot of guardianships start off as temporary when an individual has gone through a crisis or is maybe hospitalized, or there has been something happen in their lives where they need somebody to come in and make decisions for them relatively quickly, and they have not executed something like a power of attorney or an advance directive ahead of time. A court can do that with very limited information on a temporary basis, with the idea that we're going to allow an individual to go in and make decisions because it is an emergency, but it's not going to exceed past this 90-day requirement, and we have to have a hearing on those allegations to ensure that we have evidence for this guardianship to be in place before we will extend it. Permanent guardianship, on the other hand, requires actual findings of fact and evidence that it is a necessary thing to remove somebody's rights. Courts should, absolutely should, specify what parts of the ward's life that a guardianship can exercise authority, any limitations that there are on what their duties are, and what their authorities might be. Looking at the chat, I've got a couple more questions. How long does a temporary guardianship last? It can last 90 days. Of course, there has to be a hearing during that time in order to ensure that we have the evidence we need in order to continue with the temporary guardianship. It can only last 90 days unless the court has granted an extension. I believe, I don't have that in my, and I would like to look at the law before giving you a firm answer, but I believe that it can only be extended another 90 days beyond that initial 90 days under any circumstance. But like I said, I don't know that to be 100% true. If an individual is the guardian of their estate but not their own guardian, can the individual choose where they want to live? It's an interesting question, and it's one of those where you have decision-making authority that could be a bit adversarial between who the two decision makers are. They're guardian of their own estate, so they decide how they can spend their money, but they're not their own guardian of their person. So arguably they should be able to not determine where they live. But we're going to get into in a little bit what the rights of the ward are. Should the guardian be responsible of being a homeowner? So there's lots of aspects to that. I'll wait on the interpreter. There's lots of aspects to that question, and it depends on what type of guardianship, whether it's estate or person. It depends on what responsibilities of being homeowner you mean, whether it's paying the bills. A guardian of the estate would say yes. Whether it's making repairs to the property, a guardian of the person or estate might say yes, because they have to ensure that they have a habitable place in order to live. If it's a representative payee, then they have to ensure that the person is living in a habitable location. And so repairs might fall under that. It might not. After the 90 days of a temporary guardianship, does that make the temporary guardianship null and void if they don't go back to court? If it's truly a temporary guardianship and it lasts 90 days, there are no further orders, and that 90 days has lapsed, then without seeing the orders, I can't give you a true opinion, but they're only supposed to last 90 days, and they will have no force or authority unless the court has said so in its order, if they are indeed a temporary guardianship. So I told you that this was coming. We do have some due process rights, and these are not the rights we're going to be talking about in a little bit, but there are guardianship due process rights that an individual under guardianship enjoys before a guardianship is established. They have to have notice that somebody's trying to get guardianship over them. They have to have the right to respond. Those are two very important parts of what we call due process, is notice and the opportunity to respond. So they have to not only know that a guardianship is being proposed against them, but they have to have the ability to go to court and say why they agree or disagree. They have the right to counsel. Now, this is not the right to counsel that we think of when we think of criminal prosecutions. In some states, it is. In some states, we being the community at large, have decided that this is such an important thing that we are taking away from an individual that we are going to ensure that they have counsel. So if they can't afford a lawyer, one will be provided to them. We don't have that in Arkansas. We just have the right to have an attorney. So that can vary depending on the person's functioning level, their ability to understand. We believe that every individual undergoing guardianship, unless they are totally on board with it and okay with it and in agreement with it, should have an attorney to go through that process. Now, we can't represent every individual going under a guardianship or propose to be under a guardianship, but every person ought to have that opportunity if possible. They have the right to supply their own evidence, and indeed, they have the right to question the evidence that is being used to support the guardianship. They have a right to an evaluation. So guardianships can't happen without an individual who is not the guardian, who is not the court, who is a professional when it comes to identifying the person's ability to make their own decisions, perform an evaluation before a permanent guardianship is put in place. And there is a standard of proof. We do have to show that there is, that this condition, this person is in this condition that is supported by the law as requiring a guardianship. So let's talk about those evaluations because they are very important. The evaluation that has to happen before a permanent guardianship can be put in place is basically it has to be performed by a professional with expertise. It has to evaluate the person, the ward, their medical and their physical condition. Do they have any medical disorders, or what is their physical status that might impair their ability to make or communicate decisions to meet their essential needs? What is their adaptive behavior? And that is so specifically worded that there are standardized tests for how to evaluate an individual's adaptive behavior. Same with intellectual functioning. That is a term, a professional term of art. It is not something where you can have a conversation with an individual and say their intellectual functioning is X, Y, or Z. It requires an evaluation that should be, in that case, an IQ test, so that the court has objective evidence of what an individual's intellectual functioning is. And a part that's often missing from a lot of evaluations that we see is they have to have not only recommendations for specific areas that the person might need assistance, but it also has to talk about what other least restrictive alternatives could be available for an individual. And oftentimes that's skipped over in evaluations, because evaluators don't commonly, that we see, think of, can this person execute a power of attorney to do this? Can this person engage in supported decision making? Can this person just have a representative payee, or have a limited guardianship in time or in scope that might be a less restrictive alternative than taking all of their decision making authority away? And we sometimes will see that because it is possibly the safest option according to the perceptions of the evaluator. You know, if you decide that an individual's authority must be taken away, that guarantees that they're not going to be able to make bad decisions, or that they're not going to be able to make decisions. But it's really not a fair evaluation under what the definition is of incapacity. So we have to have evaluations. We've seen guardianships in some circumstances be granted on a permanent basis without ever even seeing an evaluation in the record. And courts have been very good about ensuring that an evaluation happens after the fact if it finds out that a guardianship was granted and there is not an evaluation that has been performed. We've been able to go to court and have a court order that an evaluation be performed in order to determine whether that individual actually requires a guardianship, since we didn't do it before that happened. What obligations does a guardian have? The duties of a guardian are essentially to care for the ward. They have to care for and maintain the ward. And that's an awfully squishy way to put it, but thinking about it like, what is a parent? What are a parent's obligations? To make sure that they are safe and healthy, to make sure that they have the opportunity to form relationships. If the ward is a minor, you have to see that they get an education, that they have an opportunity for getting a job, and that they have all of the things they need in order to support being more independent. But it is a substituted decision-making about everything other than their property. And this is, again, guardians of the person. A guardian of the estate, on the other hand, again, it's just about property. They have to invest that property in a way that the law allows. They have to account for the property if it's ordered by the court. And that means that they have to, in essence, provide an official accounting, sometimes at the end of every year, in order to make sure that the money that belongs to the ward is being spent on them and being spent responsibly. And that's something that we don't see happen very often. We have seen in many cases where a guardian does not understand that the order from the judge requires an accounting to be filed every year. We've seen guardians go sometimes 20 years without filing an accounting. So nobody has, in fact, monitored or exercised oversight over what that guardian is doing and whether that ward is, in fact, getting everything they need from their property or from their guardian. So what we have done in those cases is gone back and asked for an accounting to be enforced, and that is something that the courts will absolutely entertain if it's appropriate. But accountings are something that can be daunting to perceive. What is an accounting? What does it look like? So one thing that we have done is we've prepared an Excel spreadsheet that is on our website, available on our website, or if you contact us, we can send you a copy. It's got formulas in it, and it works just like balancing a checkbook. Okay, so if you record the expenses that are associated with the maintenance of the ward, with the care for the ward, if you ensure that you have proof of what's being spent on the ward, when and how, and just make a record of that and supply it to the court, then essentially you will have fulfilled your obligation to supply an accounting. All it is a tool to make sure that the court has the opportunity to see that the guardian is acting responsibly and meeting what's called their fiduciary obligations. So let's talk about oversight. With other forms of decision-making support, we don't have any oversight really. Well, we have some oversight for representative payees, but that is through something other than a court. It's through Social Security and the requirement to file accounting similarly that you would have to do in a court guardianship. Courts can exercise oversight over guardians by requiring bonds, which is essentially insurance in case they waste the individual's money. They can require inventories, which means they can ensure. I apologize. I should have actually turned that ringer off before I got started. They can require inventories before, during, and after a guardianship has been established to make sure that they know what property a ward has made available to them. They can require plans, not just for a guardian of the estate, but guardian of the person. They could ask for a plan to ensure somebody's getting access to education or health care. They might require not just an accounting of the finances, but they might require an accounting of the person. Update the court on the status of the individual, not just from finances, but how are they doing health-wise? Are they getting the supports and services they need in order to live independently? Courts could also ask for a review. And in turn, a guardian can ask for a review, which is essentially just an opportunity to go in front of the court and tell the court what's happening in the estate and perhaps ask the court to make a decision that the guardian might not understand or might not have the authority to make on their own. Now, we do have codified rights of guardians, and I've got to strike through because we used to have a statute that wasn't very old. It was enacted probably 5-6 years ago that was the right to associate with the persons of choosing. And what it originally was designed to do was to prevent guardians from limiting individuals from communicating with friends, with family. And if the guardian thought that was necessary for some reason, the guardian would have to go to court and get permission. In some cases, they would have to get permission to limit phone calls. They would have to get permission to limit contact with a relative or a friend. But importantly, that responsibility was on the guardian, the person who is not incapacitated. With the changes in the law that occurred in 2021, the opposite is now true. And so if a guardian wants to limit communication with another person and their ward, then they do have to supply notice to the ward and to the individual with whom they want to restrict communication. And if the ward is not okay with that, then the guardian is supposed to assist the ward with requesting a review by the court and ensuring that the ward gets in front of a court to talk about why they believe they should have access to that individual or the ability to communicate with that individual. And the court will review that and review why the guardian wants to limit that communication and make a decision accordingly. Now, we represent wards. We do not represent guardians under any circumstance because there are people who represent guardians and there are not very many people who represent wards. And we want to make sure that we are filling that void, providing representation to wards. But what I appreciated about the statute prior to its change was that it did put that onus on somebody who has not been deemed to be incapacitated. And while I understand that it would require a guardian sometimes unduly to have to go to court in order to make a decision that might be very important, the legislature at the time the original law was passed thought that it was an important right that we were taking away from somebody, and that if it's such an important right, it probably ought to be reviewed by a court. And I really don't like that we have now put the onus on somebody who is incapacitated. And granted, the law requires the guardian to assist them with getting in front of the court, but that is it still is not going to have the oversight and the guarantee of that decision getting in front of a court as the previous state of the law did. Now, the statute, I believe, simply says that they retain all legal rights except those expressly limited by the court. Now, it's also an interesting wording of the statute, because arguably a person loses all legal rights when they are not able to make their own decisions, the decisions of the person and the decisions of the estate. A question in the chat: can you provide information about the bill and sponsor for the bill that changed this statute? I cannot. I know that the original iteration, where we had the right to associate with persons of our own choosing, was originally passed by the family of Casey Kasem, or with the support of the family of Casey Kasem from the Weekly Top 40. And the reason they were going from state to state trying to establish that law was to make sure that nothing happened like what happened with Casey Kasem's family towards the end of his life, in which he was prevented from seeing family and friends by a guardian who was exercising that authority, and try as they might to get in front of a court to override that decision. I don't believe they were successful in ultimately doing that. So they've gone around from state to state trying to enact more protections for people who are under guardianship, to make sure that they have contact with their families and their friends in that case. But about the bill and the sponsor, it was part of a broad change to the rights of people under guardianship. A lot of it we think is really great. A lot of it, obviously, we don't lobby, but a lot of it, we question why it was necessary. But in the end, we do not make the laws. We just have to help people with them and live with them and overturn them if they are not right. But we do have this statute, which is on your screen now, or at least described on your screen now, which is the codification of the rights of wards. And there are significant rights that wards exercise, and a lot of this is really great. And we've been able to use this Wards Bill of Rights to get in front of a court with a ward on some of these situations that we see. So everybody has a right. If they're going under guardianship, they have to have this Bill of Rights presented to them. And at any point after that guardianship is established, they have a right to get a copy of that from their guardian. They do have that right, like we talked about in the previous slide, to appropriate communication and visitation with whoever they want. The limitation being, if the guardian wants to limit that, they can, but they have to help the ward get in front of a court to make that decision if they disagree with it. They have the right to all paperwork associated with their guardianship. So if there are evaluations, if there are accountings, they have the right to get access to any of that. I'm the interpreter. They have a right. Here's where it gets more broad. They have the right to a guardianship that encourages independence with a goal of termination. And this represents a shift in how we think about guardianship. So you could put somebody under a guardianship and never give them an opportunity to exercise any independence, and never have a goal of termination. But now we have that right, when it's appropriate, to have an ability for a ward to really question whether they are given the independence that they need, whether they have the right to encourage that goal of termination, and to meet some objectives towards that. It actually comprehends terminating a guardianship through the use of training and opportunities for independence. They have the right to consideration of the ward's preferences, personal preferences. That could be with regard to health care. That could be with regard to where to live. Now, granted, it only says that they have the right to consideration by the guardian of those matters. But if a guardian is making all of those decisions without ever considering what the ward wants, then essentially they would be violating that ward's Bill of Rights under the statute. They have the right to control every aspect of life that's not granted to the guardian, and that's where we come into the fight over whether the estate guardian is making the decision or the individual who has personal decision-making authority has the right to decline something or to accept something. It represents an interesting question. Arguably, they have the right to exercise full control of aspects that aren't granted to the guardian. They have the right to any information in native language or in an accessible form. So, that comports with the Americans with Disabilities Act and the requirement for effective communication. So if that ward uses some mode to communicate with, and they're not being supplied with information either in the language they speak or otherwise in an accessible form, then the guardian has violated the rights of their ward, and that can be remedied through court intervention. They have the right to be consulted on significant decisions. Again, this goes back to consideration of the ward's personal preferences, but it goes a step further. You have to consult with your ward on where they live, on specific healthcare decisions that might be significant. If we're thinking about moving a ward from an apartment into a more restrictive environment, then yes, they absolutely have to be consulted on those significant decisions. And the ward always has a right to a hearing, and the guardian has to assist them with that. If for any reason an individual under a guardianship feels like the guardianship needs to be reviewed by the court for any reason, if they feel like they're being abused or neglected, they have that right to go in front of the court. And the court should in turn listen to their considerations, listen to what they have to say, and make decisions accordingly based on that. Even though a guardian can exercise a lot of control over a person, they don't get to exercise total control over everything. And so there are these very limited decisions that will always require court approval. They're on your screen, but for the purpose of accessibility, includes abortion, sterilization, psychosurgery, removing organs except when it's an emergency situation or life-threatening, withholding any kind of life-saving treatment, authorizing a procedure that might be experimental. Authorized termination of parental rights is a very significant one, and in fact, we could probably do a whole session on the rights of individuals with disabilities as parents, but authorizing the termination of parental rights requires a totally different court action that does, because we are terminating somebody's parental rights, it's another fundamental right that requires extra protection under Arkansas law, and in that case would actually require the appointment of counsel if necessary. which is more than we require for going under guardianship alone. They can't stop an individual from getting a driver's license, so it is really interesting that they have to get court approval to get a driver's license, but also have to get court approval to allow the individual under guardianship to vote. And again, that's for anybody appointed after 2001, and that is because of that change we talked about earlier. And finally, consenting to a settlement of a claim that a person under guardianship has. Anytime a case is settled with something other than a verdict from a jury in which the ward is going to receive some kind of compensation, that has to be reviewed by a court in order to accept that. Also, institutionalization. This is something that's really interesting, and I think a lot of times overlooked, is that just because you're a guardian doesn't mean that you can institutionalize the person over which you're a guardian. You have to get court approval, but there's not a good standard for, again, just like I talked about earlier with voting and how the court's going to make a decision on whether an individual is allowed to vote. The same kind of exists with institutionalization. The court just has the discretion to determine whether the individual, in accordance with what their guardian is seeking, needs to be institutionalized. And they have to do so in, quote, a suitable institution for treatment, care, or safekeeping. So it's not, I hate criticizing statutes a lot of times, but without a good standard for how to determine whether institutionalization is necessary, we see people under guardianship often get institutionalized without court intervention. So it remains a lot of work to be done in that area. So we've talked a lot about how you get a guardianship and what you do during a guardianship. How do you remove a guardian? Well, a guardian can be removed if they themselves might require a guardianship, or if they're otherwise unsuitable or not capable of discharging what they're required to do by law. That could be a kind of a high standard, unsuitable or incapable of discharging their duties, especially if you have an individual who might have made unsafe decisions in the past, or if you have a court that might be more sensitive to ensuring safety over the dignity of the individual, which I can appreciate. Or if they have mismanaged the estate. Now that might be a lot easier to determine. If they are performing their accountings and discharging their duties faithfully with the court, then it should be fairly easy to determine how they have managed or mismanaged the estate. But not a lot of them have done that. And so mismanaging the estate might be easier to prove that maybe that guardianship isn't appropriate in the end, since it is a much more objective standard in a lot of ways. Somebody has to get permission from the court before leaving the state as a guardian, because they have to be able to be served with notice, and there's a whole procedure for that. So if a guardian has removed themselves from the state and hasn't gotten authorization to do so from the court, they can be removed for that alone. And guardianships overall, that's removal of a guardian, but that doesn't mean that the guardianship is necessarily terminated, or that the individual doesn't need the guardianship anymore, or can all of a sudden make their own decisions just because they don't have a guardian. That could put you in somewhat of a legal limbo when it comes to your personhood. So the next step would be termination of the guardianship, and that requires the court to consider whether the guardianship is no longer necessary and no longer in the interest of the ward. And it separately from that states that it can adjudicate the ward's competency going forward. But how do you do that how do you get in front of a court with that? Well, the next slide talks about how do you allege capacity? Anybody can allege capacity. Anybody could say, hey, court, this person has the capacity to make their own decisions. And at that point, once that happens, if they make that statement in writing and under oath, which would be, a notarized affidavit, then the court shall inquire into the facts of whether that person indeed has regained or has always had capacity. And that in conjunction with the requirement for evaluations prior to getting a guardianship has allowed us to get in front of a court with that very question. And arguably, looking at that statute, any person may allege that an individual has capacity would essentially allow an individual who is under a guardianship themselves to be able to allege under oath that they have capacity through an affidavit. And we have tried that before and been able to. Of course, the court is going to hear that individual out, but a good bit of caution ahead of time would be to go ahead and if you are an individual who is under a guardianship, notify the court in writing and under oath, and the court shall inquire into the facts of whether that individual has capacity anymore. Guardianship reform. Some states have made it harder to get guardianship. Some states, I talked about this earlier, has required appointment of counsel. Some states have allowed different levels of that. So some states will say everybody going under a guardianship needs counsel before we can grant a guardianship. Other states have said if any individual requests that an individual who is going under guardianship needs an attorney, then it will be appointed, whether that's the guardian, whether that's the proposed ward, whether that's just somebody in the courtroom. Any person, not very many states do that, but it is a powerful way to ensure that individuals have that right to counsel and that it is observed and appreciated. I don't really have time, I think, to talk about Olmstead and guardianship. That is, it talks about Title II of the Americans with Disabilities Act and some of the issues that are associated with that, which is a slide that I like to keep up if I have time to talk about it, but we have so much more to talk about. I'm going to scan the questions really quickly in the chat because we have kind of reached a breaking point where we're going to talk about less restrictive alternatives. The question, and I apologize for not seeing this earlier, does this include temporary guardianships even if the court has specifically requested that in the interim there is no interruption to the life of the ward? I bet this is referring to another question earlier, but I'm not seeing that right now, so I'll try to get back to that. Now is a good time to talk about if you start at 18 with a plenary guardianship. First of all, we hear a lot about individuals being told by a school that you need to really think about getting guardianship before the age of 18, because when an individual who is in school turns 18, they have the right to make educational decisions at that point. I would say that a good deal of preparation can be made for things that are less than guardianship that should be perfectly legal and in place, that don't require guardianship necessarily. I don't think it's any easier to get a permanent guardianship of somebody who is under 18 than it is to get guardianship over somebody who is 18. And I would caution that we really need to start thinking about, as a greater community, how we can limit what decisions the guardian is going to make and what decisions the ward is going to make. So can it be replaced with a less than total permanent guardianship in the future? Absolutely. Yeah, at any time a guardian or even a ward can request a review by the court. And if I will tell you that if a guardian supports limiting any of their rights under that guardianship, I can't fathom a court would disagree, because you know the person, their decision-making ability better than anybody. So if you can amend a guardianship, it doesn't require termination of the current one to be replaced with another. The court can just enter subsequent orders unless you are replacing, even in that case, if you're replacing a permanent guardianship with a temporary guardianship, which I can't see a circumstance that would be the process, but that would be the only thing where you might need to open another guardianship. But even then, I don't think so. How do we start the evaluation process that the individual needs? Well, I didn't get into this really, but those evaluations must be performed by a person who is qualified under Arkansas law. And that requires, if I'm remembering correctly, again, I would defer to the exact wording of the statute, but I believe it's physician can make those evaluations. But you're talking about getting an IQ test and an adaptive functioning test. Physicians are not really able to do that, or at least I have not met many physicians that will do an IQ test or an adaptive functioning test, at least not one that would meet the evidentiary requirements. The other type of qualified professional that can render that type of opinion is a doctor of psychology, I believe is what it says in the statute. It might say licensed psychologist, again, defer to the statute, but somebody who is a psychologist should be able to administer those tests and should be able to render a decision about somebody's ability to make their own decisions. And then the last subset is a licensed clinical or licensed certified social worker, and LCSW is also expressly recognized as being able to make decision or perform the evaluations under the statute. How and from whom do you request a state appointed guardian of an individual with intellectual disabilities that has nobody able to assist them? Now, I would recommend contacting the Office of Public Guardian. So I don't have their contact information readily available, but that office is within the Arkansas Department of Human Services. I believe it's a part of the Office of Chief Counsel in the Department of Human Services. But if you Google the phrase Public Guardian, Arkansas Department of Human Services, that should take you right to the individual or office that you could speak with for more information. I believe I answered that if your child has developmental disabilities, would it be recommended to file for guardianship or POA prior to the age of 18? You don't have to file a power of attorney for it to have force, but power of attorneys are not really good for somebody under the age of 18 that I know of. They have to be able to execute agreements like that, and I don't know without looking. I've never been presented with the question of whether somebody under the age of 18 can sign a power of attorney, but it raises the question of capacity to contract as somebody under the age of 18. Which is not one that I've thought about. I would say that when an individual with a disability, if they're capable of making their own decisions, educationally or otherwise, then if they can do so safely, if there's not a concern that they're likely to do something extremely dangerous, then trying some of those alternatives might be a good idea to ensure that they do not essentially become institutionalized even in a community setting. And by institutionalized, I mean that something that I'm afraid we're not going to have time to get into today. When I talk about supported decision making, we see a lot of support for it in professional communities, and part of that is because the ability to make decisions sometimes has greater health outcomes for individuals. let's see, the court is determined, okay, this is the rest of the question. The ward previously was their own guardian, surrounded by supported decision makers. The court has determined that they need a guardian, but the individual appointed as a temporary guardian is wanting to contradict court orders and make significant changes to benefit the temporary guardian. Yeah, Lindsay, you have my contact information. I would very much like to speak with you about that. An individual who's under a guardianship, they still have to follow court orders. And so if you're contradicting court orders, then there is absolutely a remedy for that. If the court has requested that there is no interruption in the life of the ward and the guardian is going against that, I had a slide back there that violating court orders and violating the law are reasons for removal of a guardianship. And courts hate it when their orders are not followed because they're often for good reason. Is there a list of the places that a person can go to for the evaluation, IQ testing, and adaptive functioning test? Now, yes, yes, there is. I would always start with contacting your primary care physician, and they can do a referral to a psychologist for these reasons. If you are a child, if you're talking about somebody under the age of 18 who is in public education, I guarantee you if they have disabilities and they had an IEP, they were receiving special education and related services, they will already have had done a IQ test. They will have already done an adaptive functioning test. If they haven't, then they will have been violating special education law. So you could start with that, contacting your primary care physician. If you have somebody under the age of 18, contacting the school and seeing about that evaluation, because that should have been supplied throughout somebody's education if they have significant disabilities such that a guardianship would be appropriate or warranted. You don't always need a referral to a psychologist. I don't have a list of referrals, but you know who does. If that person has health insurance, they have a list of licensed psychologists. They have a list of psychiatrists and therapists and other people who might have an idea about who you could be referred to. And those are all places that that are good places to start. Let's see. We talked a little, I got through all the questions. So we've got through limited guardianship. We talked a little bit about that. There's not a lot of guidance on it, but the court can always limit the powers or rights of a guardian, and will do so if it's necessary, if it's requested. We talked about representative payee, so I'm going to speed through more information about that. Psychiatric advance directives, it's a type of advance directive that an individual can basically present their preferences about what type of medication they don't want to have because it's had an adverse effect on them. If they have to go to a psychiatric hospital, they would prefer to be at one hospital, or they absolutely would not prefer to be at this hospital. And for the most part, unless a court has intervened, those wishes should be followed. It would be contrary to the purpose of this advance directive if, for no good reason, those requests were not followed. But also, this is supported by so much professional research because it brings agency of the individual into decisions about healthcare. And they see when individuals have psychiatric advance directives, particularly if there's a substantial likelihood that they will have a crisis that requires hospitalization. They see shorter times to recovery. They see better overall outcomes. They see the reduction of the need for emergency hospitalization for individuals in crisis. So it is a good idea to be thinking about what a psychiatric advance directive might look like if you have an individual who is interested. We have one of those on our website, a form psychiatric advance directive with directions on how to complete it. But it is a very good way to ensure somebody has the opportunity to exercise their own agency and independence. As some other things, other benefits, decrease in perceived coercion. So if an individual has explained what they want and those requests are followed, they are less likely to perceive that they're being coerced into seeking some type of treatment. Let's see, we've talked about authorizations a little bit. And, you know, authorizations, like a power of attorney, you can have a medical authorization that allows somebody to get records on your behalf. Well, that really kind of operates like a power of attorney in a lot of ways. It allows an individual to go get your medical records on your behalf. Now, it's extremely limited. It doesn't authorize them to make medical decisions on your behalf, but that's how we routinely will limit what a power of attorney can do. In this case, it is the power to go get records. You already have that right on your own behalf, and you're just giving that right to somebody else. Same thing with educational records. FERPA authorization, which is just the privacy law for education, is really a type of power of attorney. It could be withdrawn. It could be exercised by the individual who you give the right to go get records on their behalf or speak to school officials, or they don't have to do that. And it doesn't require any oversight or monitoring by the court. It doesn't require anything to be filed. And it's something so easy as a signature by a person who is authorized. I want to talk extremely briefly about assignment of educational decisions. So when we're talking about special education, and something that we hear from parents frequently is the school is telling me that I need to get guardianship before my child is 18. And that's not necessarily what needs to happen, especially if you have a parent who might not really think that guardianship is appropriate, or if you think that maybe your ward needs or your child needs more independence than a guardian might permit. So in that case, we have an assignment of educational decisions that can be signed by somebody over the age of 18 that allows a parent to make educational decisions on their behalf. There is some support for this in other states, and it's not been accepted or declined here, but we have used it in certain circumstances, and it allows the parent to continue making educational decisions. But I would say that if you have an individual who is of the age where they're getting close to 18, the IDEA supports making sure that that individual, if they will benefit from it, is incorporated into that IEP team to make sure that they have an interest in their own education, in the services that they're receiving, in what their transition planning is. So that's why I say a lot of preparation ahead of time, making sure that a child who's receiving special education through the IEP process is brought into that team, you know, sometimes as early as 14, 15, 16, to make sure that they understand what services they should be getting and what help they need, so that they will ultimately be able to make those decisions on their behalf. And I think we've got about 7 minutes left, and I'm telling you, I've got about 9 more slides to go, and I don't know that I'm going to be able to get into it. So I will go ahead and ask Lainey if she's interested. You don't have to post it in the question and answer, but I'll ask if there's any other questions to please speak now while we have just a few minutes left. And while that's going on, I will peruse quickly through the rest of my slides that we will make available after the fact. I do have a lot of slides about supported decision making. So while I'm waiting on any questions to come in, I want to talk specifically, because we don't have a supported decision-making law. Of course, that doesn't mean that you can't just execute a supported decision-making agreement, because it does allow for an individual to help make decisions in the process, allows for access to medical care. And if that can't be effected through a supported decision-making agreement, then we can supply any additional documents like a medical authorization, like an educational authorization, in order to reach into those aspects that might require something more than a supported decision-making agreement until it becomes part of law. I want to talk about why we do supported decision-making, unless we have any questions. Lainey, do we have any questions other than in the Q&A?
No questions so far.
Okay, so why do we want supported decision-making? Why do we want, we talked a little bit about less restrictive alternatives to guardianship, and I'm not saying that these are great things. The experts, the psychologists, the professionals who have a lot more school and a lot more letters behind my name who have researched this have seen that giving people's life control to be actors in their lives, to actually have the agency to make decisions, results in greater outcomes. And I'm not just talking about making them more independent and more likely to go into their communities. It actually makes them healthier to be able to make their own decisions. And think about it, if an individual is never able to make any decision on their own, how confident are we that they would be able to resist abuse or to report neglect or to even recognize it if they're not making those decisions? So it makes sense, but the idea that we are seeing better health outcomes is really stark and is really helpful for informing why ensuring that people exercise independence is so important. They are more likely to get preventative health care. They're more likely to go see a doctor, not just when they're sick, but before they ever get sick. So people who are given those opportunities are having better life outcomes. But not only that, but we see the flip side of that is when people are denied the ability to exercise agency and make their own decisions, we see that the research shows that they feel helpless, they feel hopeless, they're often more self-critical. They are less likely to ever have that guardianship terminated after it's been granted in the first place. They have low self-esteem. They might need greater services because they are under a guardianship and can't exercise their own agency. It could also have a negative impact on physical health and mental health. And again, I'm not saying this anecdotally from my perspective. This is what the researchers have found from nationwide surveys of individuals. For more information specifically on mental health law, I have those websites, the Bazelon Center for Mental Health Law, one of our stakeholders, and the National Resource Center on Psychiatric Advanced Directives. If that interests you, there's a website about that. We also have one on our website that's available with instructions for download. And here is our contact information. I will leave that on the screen while I am looking at the last question. Legal guardian of my son with autism. I can't get information from agencies such as financial aid. They told me that he still has to talk to them. Or is there something else I need to prove they need to talk to me? If you are the legal guardian of your son and they are not speaking with you about decisions like financial aid, then I would say that that's probably not appropriate, but we have had specifically the FERPA issue come up before. If you need a power of attorney for him to execute in order to be able to talk to those individuals, that is a form that is in Arkansas law. And if you reach out to us on our website after the fact, I know our intake advocate has that form readily available. So that should be something that you shouldn't take any effort to fill out. If there are no other questions, I'll turn it back over to Lainey with 1 minute to spare.
Thank you, Thomas. Thank you for the presentation. Thank you guys all for the great questions. As Thomas mentioned, if you have more questions, if you need resources, do go to our website, disabilityrightsar.org. There's a form for you to contact us. And then also he has the information on the screen. We do have some more webinars coming up later in the year. Our next one will be in January. We do invite you to register and attend that. That'll be over the waiver. Again, reach out if you have questions, and we will be sending out the recording and resources for this webinar probably next week. So if we have no further questions, thank you all and have a great day.